This morning, we have a follow-up investigation from 60 Minutes and the Washington Post on the opioid crisis that kills nearly 100 people every day. 100 people. In the first joint investigation out in October, whistleblowers revealed how a new law weakened the DEA's ability to stop suspicious drug shipments within the U.S. This new investigation focused on the biggest opioid case the DEA ever pursued against a drug company. Retired DEA agent Dave Schiller spoke for the first time to 60 Minutes. He says that the settlement against drug company McKesson was too lenient. Here's a preview of Bill Whitaker's report.
This is the best case we've ever had against a major distributor in the history of the Drug Enforcement Administration. How do we not go after the #1 organization? In the height of the epidemic, when people are dying everywhere, doesn't somebody have to be held accountable? McKesson needs to be held accountable.
Holding McKesson accountable meant going after the 5th largest corporation in the country. Headquartered in San Francisco, McKesson has 76,000 employees and earns almost $200 billion a year in revenues, about the same as ExxonMobil. Since the 1990s, McKesson has made billions from the distribution of addictive opioids. Before he retired in August, Schiller had supervised investigations in drug trafficking and money laundering cases, but he considered the case against McKesson to be the single most important investigation of his lifetime.
What did they do that was wrong?
The issue with McKesson was they were providing millions and millions and millions of pills to countless pharmacies throughout the United States, and they did not maintain any sort of due diligence. This wasn't just happening in Denver, Colorado. This was happening in Los Angeles, California. It was happening in Detroit, Michigan. It was happening in New York City. It was a national problem, and nobody wanted to deal with it.
We are now joined by Bill Whitaker and the Washington Post health reporter. That's Lenny Bernstein. Back again at the table. Your first report, guys, as you know, was jaw-dropping for a lot of people who were not aware and saw what you revealed for the very first time. Now you're back saying about DEA and McKesson together. What is the accusation this time?
The DEA requires that drug distributors like McKesson report what they call suspicious orders. And these are orders that are unusually large or of unusual frequency. And back in 2008, McKesson paid more than $13 million in a settlement because the DEA says that they were sending huge numbers of suspicious orders around the country. Shortly after they signed that settlement, DEA investigators saw McKesson doing pretty much the same thing, sending thousands and thousands and thousands of suspicious orders around the country. And they said that since this was the second time that they found the company doing it, they wanted to come down hard on them. They wanted to use them as an example to the rest of the industry. They wanted to come down hard, but the attorneys in Washington, the DEA attorneys in Washington, they were a little more lenient. And that's what our story is about.
And Lenny, why were they more lenient? Yeah. Where was the gap there between the DEA and the lawyers?
Well, you know, if you watch cop shows, you know, the investigators are always aggressive and the attorneys are always a little bit more cautious. And the attorneys have to evaluate, what can we prove? What can we actually win in court? And there is a very large divide between those two sides in this case. What we didn't realize when the negotiated settlement was announced in January was how big the gap was, how egregious the conduct of McKesson was, and why the investigators thought this was worth so much larger of a punishment.
Did the lawyers have a specific problem? Was it about motivation from McKesson? You know, in other words, it could have just been sloppy behavior, not intent. Was that what the gap was?
Intent is always difficult to prove in court. That's always a stumbling block. But what the investigators said, and you'll see on Sunday, is we had intent. They knew what they were doing in a couple of cases. We couldn't prove it. The lawyers disagreed.
It sounds like some of the politicians felt that they were duped by this law, including Joe Manchin from West Virginia, a state that has a huge opioid crisis.
Well, that's what we found. We went down to Washington and we were talking to senators there, and they were saying that for the law that we did the first piece about, that the DEA said sort of tied their hands when it came to going after these companies. The lawmakers, it was only a 3-page law. Many of them said they didn't know what was in it.
What was McKesson's response to your investigation?
We tried to get someone from McKesson to talk to us on camera, and they declined. But we spoke to the lead attorney many times through the course of this, and he basically told us that the company and the DEA lawyers all agreed that it was fruitless to look back and go back over alleged wrongdoings. Excuse me. That what they wanted to do from now on was look forward. And going forward, the company said that it would no longer behave like this. And the DEA now has an independent monitor in place to watch the company and make sure that they behave.
All right, Bill Whitaker, Lenny Bernstein, thanks so much. And you can see the full investigation of the DEA's biggest opioid case in Sunday's edition of the Washington Post, and then Sunday night on 60 Minutes right here on CBS.